Yeah, we are good to go. Can start.
Good evening, everyone, and I wish you all a very happy Ambedkar Jayanti. Thank you all for joining CEDE and LiveLaw on this special day. I'm Hamsadhwani, and I'm a fourth-year law student at the National University of Advanced Legal Studies. Today, Aslan and I will be your hosts, and we're both CEDE fellows. We're honored that we're joined by Professor Michael Klarman, a professor at Harvard Law School, who will be delivering the third Dr. Ambedkar Memorial Lecture today. Before we get to the lecture that we're all here for, Aslan and I would like to take just a bit of your time to talk about CEDE and our work. I know it's cliche, but I cannot start today's event without quoting Dr. Ambedkar. He's once said that education is the birthright of every person, and this right cannot be denied to anyone. This is extremely relevant to the work CEDE does. CEDE stands for Community for the Eradication of Discrimination in Education and Employment, and we organize internships, jobs, and other opportunities for students and graduates of law from marginalized communities, specifically Dalits, Adivasis, other backward classes, nomadic and denotified communities, transgender individuals, persons with disabilities, people from Northeast India, and other minorities. Since our inception in 2021, we have arranged close to 170 internships, over half of the interns being women, transgender, or non-binary individuals. We have arranged 5 jobs at leading litigation offices in Delhi and legal research organizations. Through our recent collaboration with the University of Windsor in Canada, we have been able to arrange fully funded overseas LLM admissions for 2 graduates. Around 150 lawyers, law firms, legal organizations, judges, and academics have graciously signed up to be part of CEDE's network, through which we arrange the opportunities I've just mentioned. We also organize and host workshops for developing the soft skills of students, such as CD building sessions and legal research sessions. CEDE's community of Bahujan students and graduates is over 500 members strong and only continues to grow every day. We hope to create a space where Bahujan students can feel safe and understood. By providing increased access to educational and employment opportunities and skill development, we're able to do a small part in ensuring the birthright to education that Dr. Ambedkar spoke about. Equally importantly, Dr. Ambedkar also said that education is what makes a person aware of his existence, potential, and power. That is where lectures like Professor Klarman's today and other events that CEDE has hosted to keep the conversation on caste discrimination in education and employment going come into the picture. Arslan will now quickly talk about a few other initiatives that we've launched over the last year.
Thank you, Hamza. I'm Arslan, a fourth-year law student at Aligarh Muslim University and a fellow at CEDE. Apart from internships and jobs, we also run 3 different mentorship programs. First is the Policy and Governance Related Fellowship Mentorship Program. We select students from marginalized communities and provide them with mentors who have previously remained fellows in different fellowships. These mentors guide our students in the CV building and SOP writing and help them hone several technical and qualitative skills essential for getting through the process. Second is the Legal Writing Mentorship Program, wherein we have collaborated with a reputed blog called Law and Other Things blog. We select students from marginalized communities and the blog connects them with their editors and senior editors. They help our students write different analytical and descriptive pieces that are eventually published on their website. They also guide our students in terms of possible career aspects. Finally, we also run a judicial clerkship mentorship program where we hold sessions to guide students on applying for law clerkships before Supreme Court and High Court judges. Without further ado, I now request Hamza to please introduce our guest.
Thanks, Arslan. I'm now pleased and honored to introduce our very special guest today, Professor Michael J. Klarman. Professor Klarman is the Kirkland and Ellis Professor at Harvard Law School. Previously, he served as a James Monroe Distinguished Professor of Law and Professor of History at the University of Virginia School of Law from 1987 to 2008. He has also won numerous awards for his teaching and scholarship, which are primarily in the areas of constitutional law and constitutional history. Professor Klarman's first book, From Jim Crow to Civil Rights, The Supreme Court and the Struggle for Racial Equality was published by Oxford University Press in 2004 and received a 2005 Bancroft Prize in History. His books, Brown versus Board of Education and the Civil Rights Movement, and Unfinished Business, Racial Equality in American History, are part of Oxford University Press's Inalienable Rights series. We're also proud to say that Professor Klarman has been part of our advisory board from the very start. With more and more conversation taking place in the USA regarding caste, the importance of international solidarity and understanding of social movements in lawyering only gains more importance. Today, Professor Klarman will be speaking on lawyering and social movements in American history and will talk about the work of African American and women lawyers. This is the first time Professor Klarman is addressing an Indian audience, and we're so happy to have you with us today, Professor. We can't wait to hear you speak.
Well, thank you so much. I'm honored to be invited to give this talk to you, the Ambedkar Memorial Lecture. Fittingly, I hope I'm going to talk to you about some of the special difficulties faced by African American and female lawyers in the United States in the middle decades of the 20th century. For the civil rights pioneers I'm discussing today, even the simple act of becoming a lawyer was very challenging. The Southern system of Jim Crow or white supremacy did not permit African Americans to become very well educated. For example, no Southern law school admitted Blacks until the 1950s. Not that many American law schools admitted women either, and they were a rare commodity in those law schools that did admit women. Harvard Law School, as you may know, did not admit women until 1950, and when Ruth Bader Ginsburg entered in 1956, she was only one of 9 women in a class of over 500. At the time of her matriculation at Harvard, women were not permitted to live in law school dormitories. They were denied access to dining tables at the faculty club, and the Law Review banquet welcomed the fathers of members, but not their mothers or their wives. Early in the school year, the dean of the law school invited the 5 women in the class to his house for dinner. During the course of the evening, he asked them why they wanted to attend Harvard Law School, where they were taking up the space that a man presumably could have put to better use. When Sandra Day O'Connor graduated from Stanford Law School in 1952, she was 3rd in her class, but the only law firm job she was offered was as a legal secretary. When Ruth Bader Ginsburg graduated from Columbia Law School in 1959, she transferred there for her 3rd year. She was tied for 1st in the class, and she was a member of both the Harvard and the Columbia Law Reviews, but no federal judge would hire her as a law clerk because they doubted whether the mother of a young child could be entrusted with that much responsibility. Moving on to the special difficulties these lawyers faced in their legal practices, it's useful to begin by thinking about what difficulties ordinary lawyers confront when they prepare a lawsuit. With regard to most lawyers and most lawsuits, a client brings a case to you. You then have to investigate the facts. You study the law to see how it applies to your case. Then you use the facts and existing law to marshal arguments that hopefully will convince a court to rule in favor of your client. It was much, much tougher than this for someone like Thurgood Marshall or Ruth Bader Ginsburg. One obstacle that Black civil rights lawyers faced in the American South, which ordinary lawyers did not, was the threat and reality of physical violence. These lawyers were challenging a deeply entrenched system of white supremacy. Most whites in the region were resistant to change, and often they were willing to use violence to prevent it. We must remember it hadn't been so many years earlier that large numbers of Blacks were being lynched every year in the South, often for conduct that was far less insurrectionary than litigating against segregation. In the 1890s, over 100 Blacks a year were lynched by whites in the South, and as late as the early 1930s, it was still over 20 a year. Even as late as the 1940s and 1950s, some African Americans engaged in civil rights protest were killed for what they were doing. Many, many others were beaten and sometimes maimed. To take an example, when World War II veteran Etoy Fletcher tried to register to vote in rural Mississippi in 1946, the registrar informed him, according to a letter he sent to the NAACP, that, quote, Negroes, and of course he used a more derogatory term, are not allowed to vote in Rankin County. And if you don't want to get into serious trouble, get out of this building, close quote. While waiting for a bus to take him out of town, Fletcher was assaulted by 4 white men who drove him several miles into the woods, beat and flogged him mercilessly, and warned him he would be killed if he ever again attempted to vote. In Montgomery County, Georgia, in 1946, an African American named D.V. Carter organized an NAACP branch, which consisted mostly of farmers and poor sharecroppers and was principally devoted to the task of voter registration. Several hundred African Americans registered as a result of his efforts. After ignoring repeated warnings from the Ku Klux Klan to desist, Carter was severely beaten. Isaac Nixon, whom Carter had persuaded to vote, was murdered. An all-white jury acquitted the 2 whites who had killed him. Harry Moore, the founder of Florida's Progressive Voters League and the chief NAACP officer in the state of Florida, was assassinated, along with his wife, by a bomb that had been planted under their home on Christmas night, 1951, in a place called Mims, Florida. Now, it wasn't just prospective Black voters and NAACP officials, but also civil rights lawyers who faced the threat and reality of physical violence. Thurgood Marshall himself was nearly lynched in 1946 while representing Black defendants in prosecutions that arose from the Columbia, Tennessee race riot. Z. Alexander Luby and Arthur Shores, who were NAACP lawyers in Nashville and Birmingham, respectively, had their homes bombed in the early 1960s because they had dared to bring school desegregation lawsuits. Now, there were other ways to intimidate civil rights lawyers in the Jim Crow South besides using physical violence. A Black lawyer named Arthur Madison sued to compel registrars in Montgomery County, Alabama, to enroll Black voters in 1944. Madison was arrested, convicted, and then summarily disbarred for representing clients without authorization. What had happened was the county sheriff had intimidated Madison's clients into withdrawing their consent to his representation. No white lawyers were willing to defend Madison at his trial. What happened to Arthur Madison was a serious problem for Black civil rights lawyers generally. Their work required them to walk a fine line around the ethical rules that constrain lawyers' behavior, the violation of which can result in disbarment or even criminal prosecution. These ethical rules for lawyers were first created with ordinary litigation in mind. For example, an individual is injured while traveling on a railroad. He or she goes to a lawyer. The lawyer sues the railroad. But organizations established to litigate for social reform often don't and can't operate that way. The NAACP often had to encourage clients to sue. It frequently had to financially support the litigation, and it needed to exercise greater control over the litigation than lawyers are customarily supposed to do. For example, NAACP officials would go to a meeting of Black teachers, inform them of their rights, for example, the right to be paid the same as white teachers doing the same work. The NAACP lawyer would tell them they could sue for vindication of those rights. That lawyer would ask for a volunteer to become a plaintiff, and then they would have to create an insurance fund for that teacher once he or she was fired from the job, which almost invariably happened once the lawsuit was brought. NAACP lawyers who participated in such events risked violating ethical rules against fomenting litigation. Clients are supposed to bring their cases to lawyers, not vice versa, as well as rules against financially supporting litigation. Clients, not lawyers, are supposed to pay for the expenses of a lawsuit. Enforcement of these sorts of ethical constraints was one of many ways that Southern states, after Brown versus Board of Education, harassed the NAACP. Another problem Black civil rights lawyers faced was the racial prejudice of judges and juries, all of whom, in the South at least, were white in the middle decades of the 20th century. Black litigants often preferred to hire white lawyers because of the prejudice white judges and juries felt toward Black lawyers. When Black NAACP lawyers argued cases before the Fifth Circuit, that's the circuit for southern states like Alabama, Mississippi, Texas, in the early 1930s who were challenging the exclusion of Blacks from Democratic Party primaries, which back then were the only elections that mattered because the South was a one-party jurisdiction. The judges on the bench who were hearing the case literally turned their backs to the lawyers, not wishing to acknowledge their presence in the courtroom. In correspondence with the NAACP's national office, these lawyers repeatedly doubted whether Southern white judges would ever vindicate the voting rights of African Americans, and they even wondered whether it was worthwhile showing up for oral argument, given that only an appeal to the Supreme Court held any realistic hope of success. Yet the Supreme Court was not always the most hospitable forum either. Justice James McReynolds, who was almost certainly the worst human being ever to sit on the United States Supreme Court, similarly turned his back on Charles Hamilton Houston when Houston argued the Gaines case in 1938, challenging Missouri's exclusion of Blacks from higher education. Now you have to think about that. Charles Hamilton Houston was a Harvard Law School graduate, a protege of Felix Frankfurter, a brilliant lawyer, and the dean of Howard Law School in Washington, D.C., and yet Justice McReynolds literally turned his back on him. Women's rights lawyers faced analogous but not identical hurdles when arguing sex discrimination cases before elderly male justices who did not always take their claims very seriously. In 1946, the justices confronted the question of whether federal statutes permitted federal courts to exclude women from juries in states where women were technically able to serve. Internal records make clear that some of the justices considered the exclusion of women from juries to be a laughing matter. Justice Douglas, who wrote the opinion invalidating a criminal conviction because the exclusion of women made the jury unrepresentative, sent a jocular note to Justice Frankfurter proposing the following revision to his draft, quote, Mr. Justice Frankfurter would eliminate all sex from juries by including only males, close quote. Not to be outdone, Frankfurter replied with a proposed addition to Douglas's opinion, quote, Mr. Justice Frankfurter, being a Victorian conservative, does not believe defendants are entitled to a sexy jury. Frankfurter and Douglas, whom you may know hated each other with a passion, could still find common cause in their juvenile humor about a case involving sex discrimination. 30 years later, oral advocate Ruth Bader Ginsburg had to confront similarly condescending humor from the bench as she challenged the exclusion of women from Missouri juries. After Ginsburg concluded her oral presentation in the case, one of the justices leaned over from the bench to ask one final question, quote, you won't settle for putting Susan B. Anthony on the new dollar then? Anthony was a noted women's suffragist from the late 19th century. In a 1970 case from New York, a state judge told a civil plaintiff challenging the absence of women from her jury not to complain to the court because her sisters prefer, quote, television soap operas, bridge and canasta, the beauty parlor and shopping over jury service, close quote. Moving on, I want to emphasize another point about the job of these path-breaking lawyers, one that I think is insufficiently appreciated today. We think of lawyers as people who go into court in pursuance of a legal claim. But in some ways, the most important job of Black civil rights lawyers and female lawyers pursuing sex equality did not take place in the courtroom. Civil rights lawyers went into Southern Black communities and tried to educate people, many of whom were still illiterate, few of whom knew much about the Constitution, to educate them about the rights they had, rights that white people were legally obliged to respect. Black civil rights lawyers such as Marshall and Houston saw part of their role as mobilizing Southern Blacks to fight against an oppressive status quo, encouraging them to believe that progressive racial change was indeed possible, boosting their morale by demonstrating to them that an outside organization cared about their interests and was committed to helping them overcome what must sometimes have seemed like insurmountable barriers to social change. Houston, the NAACP's chief litigator for much of the 1930s, saw a principal goal of the litigation campaign as, quote, arousing and strengthening the will of local communities to demand and fight for their rights. Thurgood Marshall's biographer, Mark Tushnet, writes of Marshall being brought to town ostensibly, quote, to work on pending litigation, but actually to rally the troops, close quote. In a letter to Thurgood Marshall, Houston referred to himself as, quote, not only lawyer, but as evangelist and stump speaker, close quote. Excuse me one second. The NAACP recognized the beneficial psychological effect that using Black lawyers could have on local Black communities. Southern Blacks were not accustomed to seeing Black people stand up to whites on a footing of equality or challenged what white people said. But a Black lawyer in court could, for example, accuse a white sheriff of lying when he denied beating a Black criminal defendant into confessing. Such performances had an enormous impact on the Black audience in the courtroom. Here's how Thurgood Marshall described what happened in a courtroom in a place called Hugo, Oklahoma, early in 1941, as he defended a Black man named Lyons, who was accused of murder, and the murder charges may well have been trumped up. Lyons had been beaten into confessing, a fact that Marshall was trying to get the sheriff and his deputies to admit under cross-examination. Marshall and his co-counsel, a white American Civil Liberties Union lawyer named Stanley Belden, had agreed that Marshall would do the cross-examination of all the police officers. According to a letter Marshall sent back to the NAACP's main office in New York, the reason for this was, quote, because we figured they would resent being questioned by a Negro and would get angry, and this would help us. It worked perfectly. They all became angry at the idea of a Negro pushing them into tight corners and making their lies so obvious. Boy, did I like that. And did the Negroes in the courtroom like that? You can't imagine what it means to those people down there who've been pushed around for years to know that there is an organization that will help them. They are really ready to do their part now. They are ready for anything, close quote. So it's important to emphasize for Black civil rights lawyers in the South, this was as important a part of their role as coming up with winning legal arguments. They educated African Americans about their rights. They mobilized Black communities to challenge the oppressive racial status quo. They gave Blacks hope that the world of extreme racial oppression they had always known was susceptible to change. And they provided concrete role models of Blacks standing up to whites and demanding their rights. Ruth Bader Ginsburg argued 6 landmark sex discrimination cases in the Supreme Court in the 1970s, winning 5 of them, which is not a bad batting average, to use one of my favorite metaphors, though not necessarily one of hers. She was much more, as you may know, an opera fan than a baseball fan. I think most people today know far less about what Ginsburg did outside of the courtroom in terms of helping to mobilize a movement for social change. The strategy of the Women's Rights Project, which she helped found in 1970 and which was explicitly modeled after the NAACP, included not just litigating cases, but also lobbying legislatures, training lawyers, and educating the general public about issues of sex equality. Ginsburg and the WRP offered assistance to ACLU affiliates throughout the country who were engaged in sex discrimination litigation. She helped them in setting their priorities, and the Women's Rights Project also served as a clearinghouse of information about pending cases, as well as lawyers around the country who were willing to help with sex discrimination litigation. After her victories in the Supreme Court, Ginsburg would write memos to American Civil Liberties Union branches, instructing them on how to pursue follow-up litigation, as well as legislative lobbying. Ginsburg devoted at least as much of her time to educating people about sex discrimination as she did to litigating sex equality cases. When her female students at Rutgers Law School asked for a seminar on women in the law in the late 1960s, Ginsburg spent a month in the library reading every court decision and law review article she could find on the topic in order to prepare such a course. Given the relative dearth of such material, Ginsburg later reported this was not a very taxing undertaking. Ginsburg and 2 of her colleagues also put together one of the nation's first casebooks on women in the law, and she encouraged other schools to offer such classes. She authored numerous journal articles on sex discrimination litigation, and she maintained a steady stream of correspondence with student law review editors, urging them to write about sex discrimination cases, educating them about the issues involved, providing them with briefs and other materials to enhance their scholarship, and supplying words of encouragement. She also traveled throughout the country, testifying before state legislatures in support of the Equal Rights Amendment and speaking to ACLU affiliates, university audiences, and other gatherings about sex equality issues. Social reform litigation, I emphasize again, is not just about winning cases in court. It's also about influencing public opinion in support of social change. Ginsburg was an organizer, a mobilizer, a publicist, and an educator for sex equality, much as Thurgood Marshall had been for the civil rights movement a generation earlier. Social reform lawyers not only organize and mobilize protest, but they also provide valuable role models for members of traditionally subordinated groups. I made that point a moment ago about someone like Thurgood Marshall, whose appearances in Southern courtrooms were critically important for this, among other reasons. But the same was true for a feminist lawyer like Ruth Bader Ginsburg. In 1960, there had never been a woman on the Supreme Court, and there had only been 2 or 3 female federal judges in the nation's history. As you may or may not know, there are several hundred federal judges in the country, today approaching 1,000, and there had only been 2 or 3 female federal judges in the nation's history as of 1960. In the late 1940s, President Harry Truman apparently considered, at least briefly, appointing a woman to the Supreme Court. Her name was Judge Florence Allen of the U.S. Court of Appeals for the Sixth Circuit. She was the only female federal judge in the entire country at that time. However, when Truman consulted the sitting justices about his idea of appointing a woman, they urged him not to do so, apparently concerned that her presence among them would inhibit them from taking off their ties and kicking up their feet at conference. In the mid-1960s, women were only about 1% of Supreme Court litigators, and they were less than 2% of the nation's law professors. Ginsburg did not have a single female professor during her entire 3 years of law school. Not until 1970, I find that hard to believe, but it's true. Not until 1970 did the American Association of Law Schools amend its rules to bar sex discrimination at member institutions, and as of that year, women still comprised well under 10% of law school student bodies. Ginsburg appreciated the importance of female lawyers participating in sex equality litigation in the 1970s, just as the NAACP had appreciated the importance of turning primarily to Black lawyers in the 1930s. When Ginsburg learned of the ACLU's involvement in Reed versus Reed, which turned out to be the Supreme Court's path-breaking sex discrimination case in 1971, she asked Melvin Wolfe, who was the organization's legal director, whether a woman ought not to be involved as co-counsel in the case, and he promptly invited her to join him. In women's rights litigation, Women's Rights Project litigation, as Ginsburg later noted, quote, particular attention was given to encouraging participation by women lawyers who seek assistance in maintaining their skills during periods when family responsibilities prevent them from working full-time. Ginsburg's leadership of the WRP and her oral advocacy in the Supreme Court were inspirational to countless women, and she received many notes of gratitude from those she had inspired. Ginsburg herself never failed to highlight the contributions of past generations of feminists to her own work. In her landmark brief in Reed versus Reed, she placed the names of path-breaking feminists Dorothy Kenyon and Pauli Murray on the title page as a symbolic acknowledgement of the intellectual debt owed to them by contemporary feminists. Moving on to a slightly different point, one might think that the main difficulty lawyers face is coming up with convincing legal arguments. For Black civil rights lawyers and women's rights lawyers, however, that often was not enough. The system they were challenging was so fundamentally unjust that even convincing legal arguments might not win a case. One of the most important cases, Oliver Hill, the pioneering Black civil rights lawyer in Virginia, excuse me again just for 1 second. One of the most important cases Oliver Hill, the pioneering civil rights lawyer in Virginia, was involved with was that of the Martinsville Seven, which arose around 1950. While even many civil rights lawyers and constitutional law experts today have never heard of the case, it was a big national event around 1950. 7 young Black men were charged with raping a white woman in Martinsville, Virginia in 1949. They were prosecuted, convicted, and given the death penalty. Oliver Hill helped represent them for the NAACP. Their trials were actually reasonably fair given the time and place. Unlike with many similar trials taking place at the same time in the South, the Martinsville Seven had capable lawyers who were appointed months before trial, a reasonably fair trial judge, a trial that was not dominated by a mob spirit or threats of lynching, and they had not been beaten into confessing. This was very different from some contemporaneous cases that were being held in the rural Deep South. Virginia is not part of the Deep South. By comparison, for example, Charles Trudell, a 15-year-old Black kid who was charged with murdering a white man in Wilkinson County, Mississippi in 1946, had to be transferred to another county's jail because of threatened mob violence. Defense counsel in Trudell's case was, according to correspondence that is preserved in the NAACP case files, quote, skating on thin ice in the trial of this case in a courtroom packed with a vengeful community, which overflowed even into the courtyard. The lawyers made the record as strong as they could, still quoting, without having their clients lynched on the spot, yet even a motion for a special jury veneer would have resulted in immediate violence, close quote. The trials of the Martinsville Seven were meaningfully different. Also, there's no doubt that the Martinsville Seven were in fact guilty as charged with regard to rape. There were just 2 problems with their trials and death sentences. All 72 jurors who sat in the 6 trials of the 7 defendants were white, and the state of Virginia never executed whites for the crime of rape, only Black men who raped white women. Of the 45 men executed by the state of Virginia for the crime of rape between 1908 and 1950, every single one was Black. The state could get away with that practice only by making sure that African Americans never sat on criminal juries. Hill and the NAACP raised that legal claim in the Supreme Court. The claim is not that the trial was systematically unfair, but that racially disparate administration of the death penalty violates the Equal Protection Clause. Now, it seems pretty hard to deny the justice of that claim. If the state isn't executing white men for the crime of rape, then it pretty clearly shouldn't be executing Black men for that crime either. That claim won in the Supreme Court, but not until 1977. Unfortunately, it did not win in 1951 when Oliver Hill was arguing to the Supreme Court that they should grant review in the Martinsville Seven case. Indeed, the court didn't even think the issue was worthy of review in 1951. The Martinsville Seven were executed by the state of Virginia later that year, the largest mass execution or lynching for the crime of rape in American history. Ruth Bader Ginsburg confronted an analogous difficulty in convincing elderly male justices in the 1970s of the insidious consequences of some sex classifications. The problem is that virtually all sex classifications, as Ginsburg liked to say, were a double-edged sword. Many such statutes tangibly disadvantaged males, not females, though they intangibly harmed women by perpetuating stereotypes of female dependency, passivity, and lack of business ability. Ginsburg needed to convince the justices that women were harmed, for example, by laws permitting young girls access to a certain sort of alcohol at an earlier age than boys, laws that required men but not women to pay alimony upon divorce, and laws permitting women but not men the choice of whether to serve on juries. Men had to serve, women had the option. In a telling conversation with Harvard Law School students early in 1973, Justice Potter Stewart expressed bewilderment as to why women wanted an equal rights amendment. In Stewart's view, the female of the species has, this is a quote, The female of the species has the best of both worlds. She can attack laws that unreasonably discriminate against her while preserving those that favor her. Ginsburg reported feeling depressed when she heard this account of Stewart's talk. She understood that she needed to educate the justices into seeing that all sex classifications, even those affording tangible benefits to women, always came with a cost. That cost was the perpetuation of harmful stereotypes. The most insidious of those stereotypes, Ginsburg believed, was that of male breadwinner and female homemaker. A lengthy exchange between Ginsburg and some of the justices at oral argument in Califano versus Califano versus Goldfarb in 1976 reveals how difficult it was to convince elderly male jurists that all sex classifications invidiously affected women because of their double-edged nature. The Social Security Act provision at issue in Goldfarb automatically provided survivors' benefits to the widows of covered male employees, but required the widowers of covered female employees to demonstrate that they had been economically dependent on their spouses while those spouses had been alive, i.e., they had to show that at least 50% of their financial support had come from their wives while those wives were still alive and working. To Ginsburg, a provision such as this had three distinct flaws. It discriminated against the female wage earner, it discriminated against the male recipient of the Social Security survivors benefits, and it perpetuated the invidious sex stereotype that males were breadwinners and females were homemakers. Some justices had difficulty seeing these points. The first question directed to Ginsburg from the bench came from Potter Stewart. The question was whether the provision at issue discriminated against men or women, whether it could not be seen either way, and why Ginsburg had chosen to treat it as anti-female discrimination. If the sexes were switched and only female beneficiaries were required to establish financial dependency, Stewart wondered, would that make a constitutional difference? Ginsburg's response, not surprisingly, was that, quote, the line drawn here, like virtually every gender discrimination, is a two-edged sword. Stewart persisted. Some recent court decisions had focused on the history of discrimination against women, but he doubted that any analogous history of discrimination existed against men. Ginsburg responded that, quote, most anti-female discrimination was dressed up as discrimination favoring the women, close quote. Stewart replied impatiently, I know that, but the courts, through the help of advocates such as you, have been able to see through that, haven't they? That comment elicited laughter from the audience. Ginsburg gamely reiterated sex classifications almost invariably harm women. Persisting, Stewart asked her to imagine an instance of discrimination against men. Would her constitutional argument be equally strong? Ginsburg replied that her argument would remain unchanged because I don't know of any purely anti-male discrimination. In the end, the women are the ones who end up hurting. A moment later, recently appointed Justice John Paul Stevens took up the same line of questioning. Should discrimination against males be subjected to the same standard as discrimination against females, or should it be subjected to a different standard? Ginsburg repeated her previous answer, quote, almost every discrimination that operates against males operates against females as well. Bewildered and apparently growing annoyed, Stevens responded, is that a yes or a no answer? I just don't understand you. Are you trying to avoid the question? Ginsburg insisted she was trying to clarify, not evade. She was aware of no sex classifications that did not operate as a double-edged sword. The exchange went on to similar effect for a while longer. Then from the bench came the objection, quote, but your answer always depends on their finding some discrimination against females. You seem to put that in every answer to this question. Ginsburg, who must have been growing exasperated at this point, reiterated that I have not yet come across a statute that does not have that effect. Justice Stevens persisted. But if there were one, then you would say it would be treated under a different standard, I take it. Not wishing to alienate a potential ally or making a concession that would harm her case, Ginsburg finally relented. If there were such a statute, she would reserve judgment on what the standard should be, but she repeated she had yet to come across such a statute. Now, Justices Stevens and Stewart were very smart men. Their inability to comprehend what I think would strike most of us today as a fairly self-evident point speaks volumes about the challenges that social reform lawyers face in confronting the deeply rooted ideologies that make systems of oppression seem just and inevitable. So, to sum up, Black lawyers challenging racial inequality and female lawyers challenging sex inequality confronted many distinct challenges. Black lawyers, especially in the South, face the threat and reality of physical violence, the risk of legal sanctions for ethical violations, and racially prejudiced judges and juries. Feminist lawyers like Ruth Bader Ginsburg had a hard time even securing a legal education, a hard time breaking into the profession, and a hard time convincing elderly male judges to treat their claims seriously. The world has changed a great deal in the last 50 years. A Black man not too long ago completed a very successful 8 years as president of the United States, and a woman just narrowly missed through a series of bizarre events becoming president in 2016. Two recent secretaries of state, the highest office in the president's cabinet, have been African American, and several have been women. There are 4 women sitting on the US Supreme Court today, as well as a Latina, 2 African Americans, 5 Catholics, and 2 Jews in a country that had an unofficial Protestant establishment until about 1960. Same-sex marriage, which was essentially laughed out of court as a legal claim in 1970, has now become the law of the land, and opposition to it declines significantly in the United States every year. I don't know whether I agree with the Reverend Dr. Martin Luther King Jr. about the arc of the universe bending toward justice, but I do know that it's possible to push the universe in that direction, that heroic social reform lawyers such as Thurgood Marshall, Ruth Bader Ginsburg, and Dr. Bhimrao Ramji Ambedkar have helped to do so, and that there's always a lot more of that sort of work to be done. I hope you're as inspired as I am by these heroic lawyers whose lives confirm the old adage of the great Justice Oliver Wendell Holmes, that it is possible for a man or a woman, he might have said, to live greatly in the law. There's at least that much need for such heroic lawyering today as in the past. And I know that's exactly what those of you who are enrolled in this enterprise are trying to accomplish. So thank you very much. I'm deeply honored to be invited to give the lecture, and I look forward very much to your questions.
Thank you so much, Professor, it was really an enriching speech, and I hope that participants must have learned a lot. So I will now open the forum for question and answer. Many students have sent us questions. I will read a question, then you can answer, then I will ask second question, third, like this way. So the first question goes like this: what has been the direct impact of the work of lawyers such as Marshall and Ginsburg on the lives of civil rights lawyers in contemporary times?
The question is, what's been the direct impact of lawyers like Marshall and Ginsburg on today's social reform lawyers?
On the lives of civil rights lawyers in the contemporary times.
I think there are many lawyers who are engaged in social reform litigation who very directly take their cue from the inspiration and the lessons that were offered by Thurgood Marshall. The Women's Rights Project was founded directly in response to the NAACP's litigation campaign. The Environmental Defense Fund was formed directly as a follow-up organization, as an organization that was addressed to the same sort of litigation movement in defense of the environment. The gay rights movement and all the gay rights organizations like Lambda Legal, the Human Rights Campaign, mostly organizations formed in the 1970s, saw themselves as engaging in exactly the same sort of litigation campaign. Today, the transgender movement, movements on behalf of the rights of disabled persons, those movements all take their inspiration and their direction really from the NAACP, which was formed back around 1909 or 1910. There are some very interesting questions about whether scarce resources should be invested entirely in litigation as opposed to lobbying, as opposed to social protest, as opposed to education. I think many people believe that while the NAACP did invaluable work, for example, in the Brown versus Board of Education litigation, what ultimately produced transformative civil rights legislation in the 1960s was a movement of direct action protest in the streets. And so it's probably essential that a movement for social reform not only participate in litigation and legislative lobbying, but also in educating people and shifting opinion. And that's been the most important aspect, I think, of the same-sex marriage movement and the gay rights movement generally in the United States. Litigation can only be successful after people have already prepared the path forward, and you do that by educating people through the coming out phenomenon and so forth.
Thank you, Professor. Second question is, do you think that white feminist lawyers were also able to represent the issue of women of color? What role have women of color played, and how different is it from white feminist lawyers?
Yeah, so that's a great question. We talked today about the language of intersectionality. I think it's always been true that movements for social reform that we admire in the past often shared in many of the exclusionary aspects of their time and moment in culture and history. The NAACP and the civil rights movement were not very good about gender equality, and that's one reason the gender equality movement evolved on its own in the late 1960s. The women's rights movement was not very good about defending the rights of lesbians in the early 1970s. Indeed, many of the founders of the National Organization for Women did not want radical lesbians to be part of their movement because they thought to be affiliated with a movement for gay rights in the 1970s was very much to undermine their movement. And the women's rights movement in the 1960s and 70s tended to be dominated by middle-class, well-educated Caucasian women, and they were not always very sensitive to the problems, the distinct problems of African-American women. So, you know, think about a good question of intersectionality. Black women suffer from stereotypes that are distinctive both to their being Black and their being female. So, for example, we know the stereotypes about African Americans in American history where they were not as smart, they could not be educated in the same ways. But one of the stereotypes that was distinctive to Black women was that they were sexually loose, that they did not live up to the moral standards of Victorian society. So, and of course, if you add to Black female lesbians, obviously you're adding another dimension of intersectionality, and it's not clear that Black women in the 1970s were very good at emphasizing the rights of Black female lesbians. African Americans in the United States tend to be more religious than the average American, and religiosity, especially conservative religiosity in the United States, is often correlated with hostility toward gay rights. So you could easily imagine many Black feminists not necessarily being sensitive to the rights of Black female lesbians. So I think the question's right on point, and we shouldn't be surprised by that. And we shouldn't assume that people who we honor in the past necessarily were as attentive to other aspects of exclusion. The abolitionists of the 1870s wanted to end slavery. They did not necessarily want social equality. They did not necessarily want school integration. Certainly some of them were not committed to gender equality. They didn't necessarily want women to vote. And certainly none of them were thinking about gay rights. So, you know, if we look in the past and we hold actors in the past only to the standards of today, we're not going to have many heroes. I think you have to recognize that even people who we regard as heroes probably had blinders on when it came to issues that were not necessarily the most salient issues for them.
Thank you. So the third question is, in India, a lot of socio-legal activities has been led by privileged classes who have represented marginalized communities in courts, sometimes without directly involving the community at large. So we can also make a comparison to US. Do you think the oppressor communities can bring about socio-legal change and liberate the oppressed?
That also is an excellent question, which has obvious forebearers in the civil rights movement. So the early civil rights movement, you know, the Supreme Court decision in Brown is a bunch of elderly white men trying to do something to improve the lives of African Americans. The NAACP is an integrated organization, again, of very elite, well-educated, mostly male, but some female, whites and blacks, but they don't represent the views of the average African American on the street. During the 1930s, many working class African Americans actually criticized the NAACP. They said that it doesn't really stand for the National Association for the Advancement of Colored People. It stands for the National Association for the Advancement of Certain People. So the NAACP was much more inclined to bring a lawsuit on behalf of Black teachers, of course, who are well-educated and middle class. It was not so inclined to support a boycott, an interracial labor union boycott in order to secure working class jobs for African Americans in slum neighborhoods where white-owned businesses would not hire them. I think in the 1960s, it became clear to the direct action phase of the civil rights movement that the most important thing you could do, the most important contribution, was to mobilize and educate people to take power in their own lives. And that's something that began with the Montgomery bus boycott, where thousands of African Americans, organized by the Black clergy and led by Martin Luther King, decided that they were going to boycott buses, which happily accepted their money, but insulted them, not only by segregating, but actually requiring them to give up their seats to white people, being insulted by white bus drivers. That was such a landmark event in the civil rights movement. And just think about the difference between that and Brown. Brown is 1954. It's a bunch of lawyers and some plaintiffs on the ground being given something by the United States Supreme Court. The Montgomery bus boycott is 50,000 African American protesters in Montgomery, again, with the help of some lawyers and some church leaders, but it's tens of thousands of ordinary African Americans being taught they have rights, being educated into thinking maybe if they organize together, and they had to organize in very sophisticated ways. If they're not going to ride the buses, they need to organize some sort of alternative transportation system for the Black community, many of whom have to travel across town in order to work in their jobs in white homes, for example, as cleaning people. So incredibly important to organize local communities. I think personally, this might be controversial among constitutional historians. I think the most important phase of the movement was getting ordinary Americans involved. And the power is in the people, but the people have to be willing to organize and demonstrate and mobilize, and that's very difficult to do. There was some of that after the George Floyd murder. That's what produced civil rights legislation in the 1960s, Black demonstrators on the street being beaten up on national television. That's what produced transformative change. And I think you may need that in the United States today. The Republican Party increasingly has been a threat to American democracy, and it's not clear how you solve that problem without people being willing to get out there and protest. You know, Roe versus Wade, overturning Roe versus Wade has led to those kinds of mass protests as well as involvement in politics. That's starting to pay off in a big way. You know, hundreds of thousands, millions of Americans, men and female, who are outraged at the idea that in 2023, the Supreme Court could take away a woman's constitutional right to choose what to do with her body. That's resulting, I think, in real changes in American politics, which is another kind of mobilization.
Thank you, Professor. I will just ask one last question and then we will move to vote of thanks. This next question is about diversity. Angela Davis refers to diversity recruitment policy as a strategy designed to ensure that the institution functions the same way as it functioned before, except now you have some black and brown faces. It's a difference that doesn't make a difference. Based on your work, Professor, do you think token representation can bring about change?
I would prefer not to have token representation. I would prefer to have real representation. I think if we assume that everybody is created equal, which is what I assume, one would expect there to be roughly proportional representation in all important institutions. So if it weren't for two or three centuries of oppressing African Americans, I would expect African Americans to be proportionally represented on the Supreme Court, to be proportionally represented as officers in the US Army, to be proportionally represented at Harvard Law School. Now they're not, and to the extent that they are represented more than they have been historically, it's because of race-based affirmative action, which the Supreme Court is more likely than not going to strike down this term in 2023. Again, I find that almost incredible beyond belief that in the year 2023, a conservative Supreme Court doesn't seem very troubled that you might have a mostly white officer corps in the military, a mostly white professoriate at Harvard Law School. I'm incredulous that the Supreme Court would think that's a good way for American society to be governed. To the extent Angela Davis is suggesting that minority representation does not make a big difference, I think I disagree with that. There are lots of studies showing that you get different sorts of decision making and actually better decision making. For example, if you have women on a company's board of directors, women are less likely to undertake reckless risk taking, for example. I can think of all sort of examples in my own experience where having African Americans represented makes a difference. So for example, I was talking to a student of mine a few years ago. Students get interviews for clerkships to be a judicial law clerk, and Harvard Law students, most of them are very affluent, and it's not a problem for them to fly back to a city where they have an interview. And this student said to me, you know, I'm going to go to the interview if I can find a way to afford it. That never occurred to me. That's not my daughter's experience at Harvard Law School. That's not most students' experience. Once informed of that, the law school, I think, has provided a fund. It's created a fund so that no student should have to lose access to a clerkship because they can't afford that experience. And I've seen in my lifetime, obviously, there's been a radical change with regard to sexual orientation. I grew up at a time that nobody dreamed same-sex marriage. Same-sex marriage could be a real possibility, and now it's the constitutional law of the land. How could it not affect how you think about sexual orientation to be exposed to friends and family and colleagues who are gay and see, well, they're just like anybody else. There's no reason why they shouldn't fall in love with their chosen partner and be able to get married. That's a form of education that comes through toleration of diversity, because when they were all in the closet, because the costs of coming out of the closet were so enormous, then their perspectives couldn't be openly shared. So I'm pretty certain that having more diverse perspectives with people coming from different walks of life is an incredibly valuable thing to have. And that's not even getting into the role modeling phenomenon, which is also just incredibly important. That's just a point about sharing different points of view, and people from different backgrounds do, in fact, often have different points of view.
Thank you, Professor, for answering all the questions. Now I will request Avinash to take over for a vote of thanks.
First of all, thank you so much, Professor Klarman. I think it was an enlightening lecture, and it gives a good path for CEDE to take its work forward. Seeing the work that the NAACP and the Women's Rights Project have done. I think there's so much scope for similar work to be done in India. And I think beyond that, you're right in saying that it has to be a people's movement. It has to be from the grassroots. It can't just be, tokenism in the court, token litigation, where there are headlines being written. It has to be, it has to take shape throughout the nation. And it's encouraging to see how that happened. And thank you so much for your use of constitutional history in showing us how our movements have evolved and how change has happened. I think that was the most gratifying part of the lecture, seeing where and how much evolution there has been in the last 60 years. In 1960, the US was a very different place. And I think that is reassuring. And hopefully CEDE can take that forward. So thank you so much for taking the time to come and speak to us. I'd also like to thank our community. CEDE has empaneled lawyers and law firms, judges, who each commit each year to giving a paid internship to a student from a marginalized community. As a result, it doesn't cost very much for CEDE to run because this community commits each year taking this step. And I think this is an extremely powerful statement about the need for inclusion. And we are so glad that this community acknowledges that representation is a problem and is willing to put things on the line in this systematic manner, where each year they make this commitment, and each year they take a student. So we're extremely thankful for that. We are extremely thankful for our community of students, without whom we would never be able to operate, because they give us so many ideas. They show us how difficult it is to be on the margins in society. And someone like me from a more privileged part of society learns every day. And I think it is only a community that will keep growing and will grow stronger and support each other. I'd like to help people who fund us. We just operate on a crowdsourcing model. As I said, the model is quite low maintenance. So I'm really thankful to anyone who's donated. There's some links in the YouTube chat if you'd like to donate as well, or if you'd like to be an empaneled lawyer, you'd like to take on a CEDE intern and impart some knowledge that could make a much bigger difference than helping us. But please do donate if possible. Finally, we'd like to thank LiveLaw for giving us this platform. They give us this platform every year on this momentous day, the birthday of Dr. Ambedkar, without whom I don't think this country would be the country that it is today. And I think he has defined what the idea of India, and hopefully what it will be in the future. And let's hope that remains untouched. And yes. Thank you, Professor Klarman again. Thanks, LiveLaw, and thanks to the audience for listening patiently and supporting CEDE.
Thank you very much for having me. And I hope to stay in touch, and I hope I'll see many of you again in the future. Really impressed with what you're doing and would like to support it in any way I'm able to. So thank you very much.